Welcome to the GC3 Startup Network webinar championing your ideas related IP strategies. We will give people a few more minutes to log in, so we will begin shortly. Thank you. All right, everyone. Welcome again to the GC3 Startup Network webinar on the championing your ideas with coordinated IP strategies. My name is Julie Manley. I'm the coordinator of the GC3 Startup Network. To provide some background for those new to the GC3 is the Green Chemistry and Commerce Council, a cross-sector business-to-business network of companies and organizations working collaboratively to accelerate green chemistry across sectors and supply chains. Our mission is to drive the commercial adoption of green chemistry by catalyzing and guiding action across all industries, sectors, and supply chains. The GC3 members are champions and innovators, as you can see from our more than 120 members across the value chain, including chemical companies, manufacturers of a wide variety of products, from beauty to textiles and everything in between, brands and retailers in the US as well as abroad. This webinar was organized as part of the GC3 Startup Network, an initiative within the Green Commerce Council. Actually, the Startup Network acts as at the interface between the companies and major companies in the GC3 membership. The goal of our work is twofold, really: to support the green chemistry startups in bringing new technologies to market, as well as to introduce major companies to new chemical technologies and opportunities for partnership and investment. Members of the GC3 Startup Network range from seed-stage companies to more advanced startups with a number of rounds of venture capital funds. Our startups receive the full membership benefits of the GC3, but also receive tailored resources to meet their needs. So, for example, they're able to tap into our network of major corporations through our mentoring program to seek expertise in a subject particularly relevant to them. Some of the questions we've received in the past look for market guidance, joint development agreements, and understanding just the structure and how to develop those, questions on globalization, how to value the company, and so many different questions that come in. So our startups also participate in our annual technology showcases, where we bring together startups to present and network with our large corporate members. Sometimes the topics are very focused, and other times they are intentionally broad to reach a broader scope of innovation. We're now in the midst of planning our 4th annual technology showcase, which will be at the 2019 Annual Innovators Roundtable in May later this year, hosted by Procter & Gamble Fabric Care in Cincinnati, Ohio. We're going to have 10 startups selected to be semifinalists, and they will participate in a pitch competition on May 7th. And then up from those 10, we'll have 3 selected to present on the main stage of the GC3 Annual Innovators Roundtable in front of about 200 people from all our major companies on May 8th. So pretty exciting time. So now, as we transition to today's webinar, I would like to quickly go over some logistics. Due to the participants on the call, we just want to go ahead and mute all the lines. If you have a question or comment at any time, please go ahead and type it into the questions box located in the control panel. Please type your question in at any time, and we will go ahead and answer them towards the end of the webinar. And now I would like to formally introduce our presenters today. First, I'd like to introduce Shana K, partner with Finnegan, Henderson, Faribault, Garrett, and Dunner. As a partner with one of the largest intellectual property law firms in the world, Shana provides IP counseling to innovative companies with biologics, pharmaceutical, diagnostic, and combination products, as well as represents clients in patent litigations before the U.S. District Courts and post-grant proceedings before the U.S. Patent and Trademark Office. She previously served at the U.S. Court of Appeals for the Federal Court as Judicial Law Clerk and at the U.S. District Court for the District of New Jersey as legal term. She obtained her from Rutgers University School of Law, Camden, her Ph.D. in chemistry from the University of Virginia, and her B.S. in chemistry with biology and math minors from the University of Richmond. And second, I'd like to introduce David Weingarten, associate with the same firm. David's practice focuses on patent prosecution, portfolio management, client counseling, and patent litigation before the U.S. District Courts and the U.S. International Trade Commission and post-trial proceedings at the U.S. Patent and Trademark Office, primarily in the chemical, pharmaceutical, and biotechnology areas. Prior to practicing law, David completed an NIH postdoctorate at Columbia University and then spent more than a decade in the pharmaceutical industry developing drugs across a wide range of therapeutic areas. As a member of senior management, he was responsible for leading research and development efforts in drug discovery, process research and development, and manufacturing. David obtained his JD and his PhD in organic chemistry from Emory University and his BS in chemistry from the University of West Florida. So thank you both again for offering to present today, and I will hand it over to you.
Thanks, Julie. I have enjoyed working with GC3 over the last few years, and it is a pleasure to present this webinar today on coordinated strategies for intellectual property. Typically, when we think about property, we think about tangible property. There's real property like your house, land, and there's personal property, or your computer, or your pen. When we say a piece of property, it means that we have certain property rights. I own my pen, so I have the right to use it, the right to keep you from using it, and the right to transfer my rights. I can loan my pen, rent it, or even sell it. So how is an idea different from a piece of tangible property? Well, the tangible nature of my pen means that if I'm using it, someone else can't be using it at the same time. But if I have an idea, I can share it with others, and we can all use it at the same time. So, is it possible to own your ideas? Well, the answer is no, you can't. But certain creations of the mind are given certain property rights, and these creations are called intellectual property, or IP. Today we'll be talking about four main types of IP. There are patents for inventions and discoveries, trade secrets for information that is secret and valuable, copyrights for original work, and trademarks for logos, slogans, and other source identifiers. Now, as you think about the different types of IP, you want to think about what you can get from having an IP portfolio. Perhaps you want to protect your own ideas in the market. Perhaps you want to establish IP rights to exclude competitors from practicing your ideas. You may want to develop an IP portfolio to attract investors. I have heard that the number of zeros in a company's valuation is proportional to the number of patents they have. You may also want to develop an IP portfolio to generate revenue. Perhaps you have an idea that you want to use and that your competitor doesn't want to use, but there's a third party who would be willing to pay you to use the idea as a licensee. You can keep all of these reasons in mind as you think about your IP portfolio and your business objectives. So the first type of IP that we're going to talk about today is patents. A patent gives you the right to exclude others from practicing your invention in the United States. If they do, it's called patent infringement, and you can sue them in federal court. Now, it's important to note that there are actually three types of patents. Plant patents protect new varieties of plants that have been asexually produced, such as the yellow rose plant on the left side. Design patents protect ornamental designs of articles of manufacture. That is the way an article looks. So the example on the slide is the design of Michael Jackson's anti-gravity shoes that allowed him to lean forward, seeming to defy gravity. Other examples of design patents can be anything from the design of a car part, to the design of a medical device. The third type of patent is the one that we will focus on today, utility patents. Utility patents protect the way an article is used and works. So it's possible to obtain both design patent and utility patent protection on an article if invention resides in both the ornamental appearance as well as the utility. So we have patents to promote innovation. To obtain a utility patent, you must file an application with the U.S. Patent and Trademark Office and meet certain requirements that we'll talk about today. After you file the application, you must withstand examination at the PTO. This is a process known as patent prosecution. You may need to make arguments or amendments, but ultimately, hopefully, you end up with an issued patent. It is important to note, though, that getting a patent is not the end of the story. Competitors may be able to attack your issued patent at the PTO or in court during litigation. If you withstand examination and any challenges that may come your way, the patent will last for 20 years from the effective filing. Issued patents have three main parts, in addition to the cover that the PTO actually just released in 2018, which is shown on the slide. The summary page will have the title of the invention, the names of the inventors, and possibly the assignee who has been assigned rights in the patent. The specification or body of the patent describes the invention and the object of the invention. At the end of the patent are the claims. Patent claims identify what you are claiming as your invention. It is what you are saying that no one else can make, use, sell, offer for sale in the United States, or import into the United States. In other words, claims are the facts that provide your protection. As you're thinking about the claims to include in your patents, you want to think about different scopes of protection, different sized fences that you can put around your invention. So for example, let's say you invent a compound of a particular formula that includes a chlorine. As you're preparing your claims, you want to think about whether your invention would also work if you replace that chlorine with a fluorine. Would it also work if you used any halogen atom there? If so, you would want to consider including claims of varying scope, claims that include a chlorine atom at that position, as well as claims that include any halogen atom at that position. You also want to consider different types of claims. So for our compound example, we're claiming compositions comprising the compound, methods using the compound, and methods of making the compound. As you write your claims, you need to choose the words carefully, and you need to make sure that the specification, the body of your patent, supports the words you are using. If you sue someone for infringement, the court will decide the scope of your claim and then whether the accused product falls within it. So let's look at an example. In this case, AstraZeneca had a patent with claims like the one shown here to a pharmaceutical formulation comprising a pure solid-state alkaline salt of the compound known as esomeprazole. AstraZeneca sold the magnesium salt of the compound as Nexium. When me sought FDA approval to market a strontium salt version, AstraZeneca sued Hanmi for patent infringement. So the court had to decide what the scope of AstraZeneca's patent claim was, that is, how big was AstraZeneca's fence, and then whether Hanmi's product fell within the scope. The court determined that the words alkaline salt in the claim were limited to 6 salts in the specification, and strontium was not one of them. Hanmi was found not to infringe this claim simply because they chose to use a strontium salt. So you may be asking why you wouldn't just write really broad claims that capture all possibilities. You may think you should draft a claim that covers all possible compounds and all possible salts of those compounds, for example. But you need to remember that when you're drafting patent claims, you need a careful balance. You want claims that are broad enough to cover your products, but those claims also need to meet the requirements for patent validity. So I'm going to hand it over to David now to talk about those requirements.
Thank you, Shana. So as Shana indicated, there are certain requirements for patentability, for filing and obtaining a patent with the Patent Office, but then equally important is maintaining the validity of the patent during litigation. One of the things that the Congress set forth in determining the patent law is that there are statutory categories that are deemed to be subject matter that one could obtain a patent on. These include new and useful processes, machines, manufacture, or compositions of matter, or improvements thereof. Now, for many years, the bar and the courts interpreted the requirement for patentable subject matter to mean, with some exceptions, that anything under the sun that is made by man is patent eligible. This was not really much of an area of contention. There were some cases here or there, but more recently, the Supreme Court in 2012 started to come out with a number of landmark decisions where the court articulated a framework for determining whether something is patentable subject matter. And it's something that is still not totally clear today, as the courts continue to struggle with the Supreme Court. The lower courts are trying to determine what the Supreme Court meant by patentable subject matter. The Supreme Court framework, just to briefly explain, said that you needed to first determine whether the patent claims were directed to an exception, a judicial exception, which included things like an abstract idea, a law of nature, or natural phenomenon. And then if it was not directed to one of those, it was patentable. But if it was directed to one of those exceptions, then you had to see if there was something substantially more. One of the cases that I find very interesting in talking about what a judicial exception is the Supreme Court Myriad decision, where the Supreme Court stated that it does not need to be an old or long prevalent idea or to be considered a judicial exception. Something that's newly discovered and even novel could still be something that would go up to a judicial exception and not be patent eligible. In this case, Myriad had spent a lot of resources trying to identify, and in fact identifying, genes related to having an increased risk of cancer, breast and ovarian cancer. And they obtained patents and then even offered tests to women to determine whether they were increased risk. You may recall in the news back in 2013, Angelina Jolie obtained a preventative double mastectomy, and that was a result of her having this test performed and determining that she had an 87% chance of breast cancer. So there was a lot of debate at the time about whether Myriad's claims would withstand the patentable eligible subject matter. And in the end, the Supreme Court said claim 1, which was directed to an isolated DNA, which was in its natural form, but excised from the sequence as a whole, was not eligible. But claim 2, which was directed to a version of DNA which excluded pieces, was patent eligible because it doesn't exist in nature that way. It didn't matter that Myriad had spent a lot of resources and time and discovered this relationship. It was more important to make sure that the things that are in nature are available for others to use to develop additional inventions. The USPTO has come up with a number of examples to try to more further explain the substantially more requirement that the Supreme Court iterated in its decisions. And we're not going to go through this slide in any detail. The purpose of this slide is just to demonstrate that how seemingly small changes in claim language can affect subject matter eligibility. If you look, for example, at example 28, which relates to vaccines, claim 3, the USPTO in its example says this would not be patent eligible if peptide F is known in the art and carriers are known, and you put them there and there's nothing new that comes out of that. But claim 4, by going and limiting the carriers to a specific subgroup, was patent eligible. Similarly, if you look at example 29, the only difference between claims 2 and 3 is in claim 3, it was limited to a particular antibody, one from pig. And that was considered to be a patent eligible, whereas claim 2 is not. And there, the reasoning that the USPTO gave in its example was that the use of that particular antibody was not something that was conventional in the field, and therefore this is something more. So you have to have this subject matter eligibility, be in one of these, not be directed to a abstract idea, etc. But that's not the only requirement you have. I said you must be directed to a new and useful. And so the useful aspect of the requirement is referred to as utility. And what a utility means is that you must have a use for the invention that's either clear based upon the description and the specification, It must be specific and substantial, or it must be well established. And well established means that one of skill in the art would immediately appreciate why the invention is useful. Now, even though that there is a specification that may disclose why an invention is useful, and that statement that an inventor makes would be regarded as true in general, it must be credible. And that's an important concept, because if the statement is not considered credible, then a court may find that an invention lacks utility. It doesn't have to be wholly operative, however. As long as part of the invention is operable, at least it achieves some useful result, it would be satisfy the utility requirement. Now, one example which I find interesting, where the court in fact found that the invention was inoperable, has to do with a beverage that was said to be enhanced. And in this particular case, the beverage could be chicken soup. So I guess you can drink your chicken soup. But the beverage was exposed to a magnetic field and claimed to enhance the flavor of the beverage. The patent office said that this was not something that was believable, and in fact they said it was highly unbelievable and rejected it. In this instance, the applicant in fact put together some evidence, had an expert provide testimony and some testing to try to demonstrate that it did in fact enhance the flavor. That evidence was considered not to be persuasive, and the patent office did not end up providing a patent in this instance, and the Fed Circuit affirmed. In addition to having utility, as Shana mentioned earlier, your patent specification, your application must provide a description, and that description is referred to as written description that shows the inventor had possession of the invention. The claims must be enabled, and enabled refers to you must show one of skill in the art how to make and use the invention without undue experimentation. And there's a connection between utility and usefulness. Obviously, if your patent lacks utility, if your claims lack utility, then that means you likely have not shown how to use it because there is no use, or at least one that's credible. And then the other aspect, which is an important aspect with regard to defense that Shana mentioned earlier, is that you must distinctly claim in your invention, and that's the definiteness requirement. And there, what you're trying to determine is with reasonable certainty what the scope of the invention is. If you're unable to determine the scope of the invention, the claims would be said to be indefinite and not valid. And this can come into the case when a claim term's meaning is not understood. Now, regarding the enablement requirement, you need much more than a hypothetical possibility in order for you to satisfy that requirement. In this NRA 318 case, this is a Janssen Pharmaceutical patent application in which the issued patent was related to the treating an Alzheimer's disease using a therapeutically effective amount of a drug referred to as galantamine. And here the specification was slightly longer than a page. Now, I've been doing patents for a while, and I don't see very many patents that are limited to one page of a specification. But here it was about a one-page specification, and it contained really just brief summaries of 6 scientific articles, which discussed the use of that compound, but not in the treatment of Alzheimer's or related diseases such as dementia, but for other purposes altogether. And when that patent was challenged, the lower court found it invalid for lacking utility, but also not enabled. And the Fed Circuit affirmed, stating that the specification does no more than state a hypothesis and propose testing to determine the accuracy of the hypothesis. The concern here is that if the court allows a broad claim like this without any support for obtaining a result, without enabling the claim, that one could file patent applications with simply rights to what they refer to as, quote, inventions that consist of little more than respective guesses. And then ultimately, if one of those guesses turns out to be true, that you would be reaping the reward when others really deserve that reward. And we referred, I mentioned earlier about not understanding what the definition of a term means. Well, sometimes that's because the term could have multiple meanings. In this particular example, this was related to Eli Lilly's drug called Alimta, which was for cancer therapy. And the claims were directed to the administering a particular drug in combination with a methylmalonic acid lowering agent, which could be vitamin B12. Now, looking at this claim, I would think in the initial view, people may say, well, what's wrong with that? It's vitamin B12. And in fact, when the patent application was written, it probably was not second guessed. But during litigation, the defendants challenged the claims as being indefinite because vitamin B12, in fact, can have multiple meanings. The meanings could be to the cyanocobalamin specifically, or it could be to a class of compounds that include pharmaceutical derivatives of that. And if you looked in the prior art as a whole, or even in the specification, it used the term both ways. And if you don't know which way it is intended in the claims, then the defense is unclear and the claims could be indefinite. In this particular case, the court found, based on expert testimony, that doctors would understand the claims to mean the specific compound and not the class of compounds. And therefore, the claim was found not to be indefinite, and therefore, it was still valid. But it's something just to keep in mind is that when you draft a patent application, think about the kinds of claims and the kinds of words you use, and if things have multiple meanings. And if it does, then you may need to have special caution in the way the claim is drafted or the spec is written. In addition to the requirements for written description and enablement and indefiniteness, your claims must be, and this is what most people usually hear about, they must be novel, right? They must be novel and not obvious. We'll talk about novelty here. And what novelty refers to is that they must be new. An invention that is not new is not patentable. And how do you know if something is new or not? Well, what the patent office does and the court does is they look to see if the invention has been described in another patent or a publication, or if it's been in public use or on sale before the filing date of the claims. And if it has, then it's not novel. And if it's not novel, then you have to recognize that novelty generally is judged based upon looking at one particular reference at a time, not by combining pieces from different references. That'll be obviousness. We'll talk about that in a minute. But if something is anticipated, meaning not novel, because there's something in the art that teaches that invention, then your invention is not novel and not new. But sometimes the novelty rejection or the lack of novelty is something that happens not because it's expressly disclosed in that prior art, but because it's inherent. And we'll talk about that a little bit. And this is a great example. This is an example of Schering's drug related to Claritin. And here, the Schering had sued Geneva. The patent, the earlier patent related to Claritin, had been filed and obtained. And during that process, Schering discovered that Claritin, when administered in humans, would form a metabolite, and that metabolite shown on the right, and that's referred to as DCL. And nobody knew this. Nobody knew that if you took Claritin, it would form DCL on the right. Schering attempted to obtain patent claims to the compound on the right. And the Fed Circuit affirmed the lower court, saying that the patent to the claim on the right would be invalid because it's anticipated. And you know, a lot of scholars and people, patent attorneys at the time, found this case very interesting because there was no actual application of Claritin to people at the time that the patent application related to the compound on the right was filed. The Fed Circuit said that that the compound that's on the right is not formed accidentally or under unusual conditions. When the compound on the left is ingested, it necessarily and inevitably forms. And if it inevitably necessarily forms by administering the compound on the left, and the disclosure of the patent for the compound on the left talks about its administration, then that would be sufficient to inherently anticipate a patent directed to the compound on the right. So that's just an interesting case because actual administration of the compound on the left to a patient was not relevant to the situation as long as you had an enabling disclosure. The other thing that we mentioned a second ago is that if the patent invention is on sale, well, on sale does not necessarily mean that it has been sold. We won't go into the details of this case, but here the patent was found not to be valid because of an offer for sale that took place more than a year before the filing of the patent application. And so not only do you have to be concerned with written publications and disclosures, but you have to be concerned with offers for sale and sale. And there's been a more recent Supreme Court case that came out last month, you may have heard of, that says that even if under the current law, even if the sale is secret, it still could qualify as a invalidating prior art. And the last piece I'd like to talk about with regard to the novelty is a previous disclosure. This is a very interesting case. This is a case in which you had a graduate student performing research and coming up with this invention and telling his research advisor. His research advisor goes on a trip and rides on the bus, and part of that bus trip he is speaking with another scientist from Monsanto. And he tells the scientist from Monsanto about this idea that his student had. And the Monsanto scientist goes back to the lab and implements the idea. Implements the idea in the lab and uses it to test Roundup to determine whether Roundup was safe for the environment. And lo and behold, later on, the patent gets issued and gets assigned to the National Research Development Corporation, who sued Varian for infringement of the patent. And in the end, the patent was found to be invalid because Monsanto had used the invention more than a year before the patent application had been filed. The court said it didn't matter whether the graduate student knew it or it was the graduate student's fault that information got out. That's not the point. The point is that at the time of that disclosure, there was no request for confidentiality or requirement to not disseminate. And in the end, that prior use before the patent application was sufficient. So the take-home message of this is that you have to be careful when you are giving presentations at meetings, whether you're talking to other people about your inventions prior to the time of the filing of the application, because those events could trigger something, either trigger at that moment or through a cascade of events, things that would then result in the lack of novelty. And you can't recover from a lack of novelty. The next aspect, and the last aspect with requirements for patentability, will relate to obviousness. In order to obtain a patent, even though it's not identically disclosed in the prior art reference, you also have to make sure that the differences between the claimed invention and the prior art are such that the claimed invention would have not have been obvious as a whole. And that's by looking at more than one reference. If I were to take 2 references or 3 references, or even the knowledge of one of skill in the art, would that invention really just be an obvious thing to do? And in the chemical arts field, the obviousness analysis often leans on what's referred to as the lead compound analysis. And here it's a 2-part test really that says, would a person of an ordinary skill in the art have a reason to select a particular compound as a starting point, and that compound's in the prior art as a starting point, and would they have been motivated to modify it to obtain the invention with any reasonable expectation of success? In this representation of the slide, you see that Takeda is representative of the first part, the selection of the lead compound. Here, Takeda sued the company seeking to market a generic version of Actos. And Actos is a pioglitazone compound on the bottom right-hand side. And the generic company, or the company that they sued, claimed that the patent was invalid. It's obvious because the difference between that pioglitazone compound and a compound B within the prior art was that that instead of having an ethyl group, which is shown in the green on the bottom right, it was a methyl group. Vice versa, I'm sorry. Instead of having the methyl group in the prior art, it's an ethyl group, and that change would have been an obvious starting point to go with. And the court held that while there are structural similarities, I mean, certainly looking at B and pioglitazone, they're structurally similar, that there would have been no reason to start with compound B, because compound B was a known toxic compound, which would cause weight gain, whereas pioglitazone was being developed for diabetes. So why would you choose something that's toxic and gaining weight in a compound that's meant for diabetes? So in this particular case, the compound was found not to be obvious, and that was not a good lead compound beginning. In addition to having to identify a lead compound, I indicated you have to have a reason to modify it. Not going to go into the details here, but the reason to modify it can't go against the basic fundamental reason for a compound to exist and for its use in the prior art. Here, the compound that was being developed in the invention was revifrazole, and in the prior art was lansoprazole, which is on the top right. And the court said there would be no reason to start with the lansoprazole and modify it by removing the fluorine atoms, when it was known that the fluorine substitution provided the special path to achieving the lipophilicity you needed. So again, why would you take away a piece that was necessarily associated with the reason that was a good compound? You wouldn't do that, and therefore you wouldn't have a reason to modify it to obtain the claimed invention. And even if one were to think that you would modify it or could modify it, you have to have a reasonable expectation of success. That's the last part of it. And here, Procter & Gamble had claims to a compound called residrodronate. Sorry, I'm mispronouncing it. And the prior art compound was simply an isomer where the nitrogen was in a different location. But because the art was unpredictable in the area, the court said that that these kinds of compounds are unpredictable, and therefore one would not expect the activity of one to necessarily or the properties of one to correlate with the properties of the other. So these are the kinds of arguments, though, that when you file a patent application and you're asserting a patent, that are going to be challenged the claims based on validity of novelty as well as obviousness. And on the obviousness in the chemical, it's usually this kind of analysis. Now, even if the claims were to be argued that it would have been obvious to choose a lead compound and to make certain modifications with some reasonable expectation of success, there is some objective indicia that the claims may not necessarily be obvious if you can show additional things like long felt but unmet need, failures of others. These are things that, if the art taught away, for example, from doing what I'm doing, then how can what I'm doing be obvious? Or if there's skepticism by experts, if people are skeptical that this would work, then how can what I'm doing and it worked be obvious? And so these are the kinds of things that people look for. But when you are relying upon objective indicia to sort of overcome these arguments on obviousness, you have to be careful with your scope of your claims. And as Shana indicated earlier, you can have claims that are narrower and broader, and often you have a combination of that. But in order for the objective indicia to apply, it has to be commensurate in scope with the claim. So if you've got a narrow claim, then that claim may have a better suitability to these objective indicia than a broad claim, where there may be multiple compounds within that claim, but you don't necessarily have the same beneficial, commercial success, for example, or copying for all the compounds within that claim. So you do have to make sure, and you have to make sure that there's a nexus, meaning that the basis of these objective indicia are related to the claim itself, and not through, for example, because you marketed the compound in a particular way. And the last slide I'll talk about here before turning back over to Shana is the strategies, because all of this is being explained for one big purpose, and that is to understand what the strategy needs to be when trying to obtain a patent. I mean, first of all, you have to start with harvesting the inventions. You've got to get the inventions from the inventors, and you have to recognize that not all inventors will realize the scope of their invention, and you have to file applications to various scope to understand what we're working on today and what they could be working on tomorrow. And you have to time those filings. You have to time those filings for when you think that the patent will come out, when the patent will be beneficial. But more importantly than that, in many companies, because your IP is tied to your value, you have to also make sure that you're not disclosing information that would result in a lack of novelty. Because again, it's sort of this prior art aspect. You want to identify continuation opportunities. It's not a one and done situation. You file patent applications, but you may make improvements. If it's a composition, you may find better compositions. If it's a compound, you might find an improved compound. And you want to use patent markings, and what that refers to is that you want to be able to mark your products, if you have a product, with a patent, which would then provide notice effectively to others and potential competitors that you do have a patent, and that triggers damages, etc., related to infringement suits. And you want to have a monetization program. That monetization program could be something that allows you to either sue or license, etc., monitor others, and enforce. So with that, let me turn it over to Shana, who's then going to pick up from here.
Thanks, David. So the next type of IP we're going to talk about are trade secrets. These protect information that is secret and valuable. Having a trade secret means that others cannot obtain the information by theft or improper means. Others can also not disclose the information in violation of a confidential relationship. If they do, you can sue them in federal or state court for trade secret misappropriation. Now, trade secrets can be recipes like those for Coca-Cola or McDonald's Big Mac special sauce. They can be for non-food formulas like WD-40. But trade secrets can also be information like Google's search algorithm or the definition that the New York Times uses for a bestseller. Trade secrets can be pricing strategies, budgets, business plans, supply and distribution chains, customer lists, customer preferences, data compilation, scientific know-how, processes, basically anything that is both secret and valuable. So unlike with patents, you don't actually need to file an application to get a trade secret. You get the protection as soon as you have information that is not known, not readily ascertainable, and that has value because it's secret. To keep your trade secret, you must take reasonable steps to maintain secrecy. If you do so, you can keep your trade secret protection until the information is no longer secret. This means that trade secrets have the potential to provide protection well beyond the 20 years that you would get with a patent. So looking at an example, around 1970, DuPont had a process for making methanol that it protected as a trade secret. DuPont was constructing part of the plant and part of the roof was missing. So someone hired two brothers to fly over the plant and take aerial photographs of the secret process. DuPont ended up suing the brothers for trade secret misappropriation. So the court had to determine whether DuPont had made reasonable efforts to maintain the secrecy of the process. And the court decided that DuPont had, that it was reasonable. Now, this case was from 1970. It might have gone a different way if it was decided today in the age of drones. But at least in this case, the court decided that DuPont didn't need to move the process to a different plant. They didn't need to put up a temporary roof. They decided that DuPont had made reasonable efforts. So a lot of times we see trade secret cases where someone changes jobs and takes information with them. In this example, there was a regional director at Korn Ferry named David Nozel. And Korn Ferry had kept as trade secret information related to its internal databases of over 1 million executives. When Mr. Nozel left Korn Ferry, he first downloaded information from the database, worked with others to do the same. He then launched his new company and continued to use his former assistant password to access the database, even though he no longer worked for Korn Ferry. So in this case, it was actually a criminal case that was brought against him, and Mr. Nozel was found guilty of theft. He was sentenced to 1 year in prison and 3 years of supervised release. He was also ordered to pay a $60,000 fine and $828,000 in restitution to Korn Ferry. And now this was a criminal case, so it would be in addition to any civil cases that would have been brought. So with trade secrets, you can't stop others from discovering the information through independent invention, accidental disclosure, or reverse engineering. Reverse engineering is when you take publicly available information and work backwards. So in this example, Chicago Locks sold high security tubular locks and protected information about the locks as trade secrets. If a customer lost their keys, they would have to actually turn to a skilled locksmith to pick and decode the lock. So Mr. Fanberg was a locksmith who decided to compile a manual with all of the codes he had identified and the codes from other locksmiths. Chicago Locks sued him, but the court ruled that Mr. Fanberg did not misappropriate trade secrets. Instead, it ruled that discovering the serial number key code correlation was an example of independent invention and reverse engineering. So there was no trade secret misappropriation. Now, as you're developing your IP portfolio, you should consider using both patents and trade secrets and identify when you would want to use one versus the other. For example, if you have information to be reverse engineered or independently discovered or information that's difficult to keep secret, you would lean towards seeking patent protection. If, on the other hand, you have information that would not be eligible for a patent, like David talked about, you would lean towards trade secret protection. You would also lean towards trade secret protection if the information has a commercial value of shorter than the 2 or 3 years it would take to get a patent, or longer than the 20 years that the patent would last. So let's talk about some trade secret strategies that you want to think about. You can restrict access, for example, by locking doors, not allowing visitors to tour certain parts of your office or lab space. You can establish a written trade secret policy that includes the steps you are taking to maintain your secrets. You can use confidentiality agreements with third parties and employees, but you should also remember to restrict access in the first place. Only disclose what you need to, and then do so with a solid agreement in place. You can train employees on how to identify and protect trade secrets. You can use legending to mark your trade secrets. For example, you can use your company name along with words like proprietary, confidential, highly confidential. You should monitor authorized and unauthorized access to your trade secrets, and you should enforce if needed with cease and desist letters or litigation in state or federal court. And now I'll hand it back over to David for the next type of IP. David, you'll be on mute.
Thank you, Shana. The next area of IP is going to be copyrights. And copyrights protects creative works such as poetry, movies and plays, video games, paintings and photographs, sheet music, record music performances, novels, software codes, sculptures, choreography, architectural designs. These are just a few of the things that are considered creative works. The purpose of copyright law is to promote the progress of useful arts and science by protecting the exclusive rights of authors. Now, to qualify as a copyright, one must have a creative work that's fixed in tangible form. It has to be a tangible medium of expression. This means that the work must exist in a physical form, at least for a brief period of time. And then, of course, it must be an original work. Once you have a fixed work in tangible medium, the period of protection for a copyright for works published after 1977 is the life of the author plus 70 years. Now, if the work is a work for hire or is published anonymously or under some pseudonym, the copyright will last between 95 and 120 years, depending upon the date the work published. Now, this serves as a general warning to many of you on the call, and that is that often we think about, I'm just going to make a photocopy of this journal article, or I'm going to make a photocopy of this book page, and technically those things could be considered to be copyright infringement. And copyright infringement is something that we have to be careful about, and that's the case, the American Geophysical Union v. Texaco case. Here, the Texaco was in the habit, it had like 400 scientists or so, but was in the habit of purchasing one copy of a journal article, a journal. subscription and making copies of the articles within it for anyone who wanted, within the company who wanted access. And the American Geophysical Union, the group of authors, sued Texaco, arguing that they infringed the patent, the copyrights, I'm sorry, by making those copies. Texaco tried arguing fair use, and fair use is an exception to the copyright, and that is that while there may be ability to protect, there needs to be some ability for the public to use that in certain ways. And in this particular case, the court found that copying was not fair use. And that's a factual analysis. We're not going to go into it. But here, the reason the court found that was not fair use was that Texaco's primary reason for copying was to avoid payment, and that the entire articles were copied. It wasn't just a small portion, and that the copying caused us a loss of subscription revenue to the authors of the journal. Now, in contrast to that, there was, many of you, I'm sure, have used Google Books to search for books and to see if a particular book has information. And that was the subject to the lawsuit of Authors Guild v. Google in 2015. Here, the court, in fact, found that Google's use of the information, copyright information, was fair use, even though Google did it without the permission of the rights holder, which you don't need permission for fair use. And the court said that, look, while they made digital copies of the entire book, this was not a small portion of the book, it didn't reveal that copy to the public. The public was able to search, have limited search functions and only see limited information within the books, and that served a useful public purpose, sufficient to allow it to do so in the context of fair use. So what are some of the copyright strategies one must follow? Well, first of all, your work is copyrighted or you have copyright protection the moment it's created in fixed and intangible medium. There's no requirement to have it registered in order for it to be a copyright. However, if you want to have some of the benefits that come with copywriting, such as the ability to bring a lawsuit for infringement in the United States, you need to register it. And so that's one of the major benefits. The other benefit is that puts people on notice. By having that, Circle C, if you will, one would understand that the creative work is protected by copyright. And so that's something to keep in mind. But you want to provide that notice with the Circle C. You want to put the monitor others' use and enforce it. So otherwise, delaying on enforcement may lose your ability to obtain any damages from that infringement. And with that, I'll turn it back over to Shana.
Okay, so the last type of IP we're going to talk about is trademarks. These identify and distinguish the source of goods or services, and having one means that you can keep others from infringing, blurring, or tarnishing your mark. So trademarks are words, logos, slogans, colors, the appearance of a package, basically anything that identifies a source. You don't need to file an application to get a trademark. You just need the mark to identify and distinguish you as the source of the goods or service. But registering your mark with the PTO will give you certain benefits. Once you have a trademark, it lasts until it's abandoned or no longer identifies and distinguishes a single source. Now, as we're looking at words that are used as trademarks, there are actually 5 different categories that are shown on the slide here, and the words actually get stronger as you go up the ladder. You can't use a generic word like Apple for an Apple store, but you could use it in an arbitrary way, and in fact, Apple has done that. At the top of the ladder are fanciful made-up words like Kodak, Xerox, Exxon, Buick. These are considered the strongest type of word mark. Now, once you have a trademark, others can't use the same or similar mark where it would cause confusion. So in this case, the court actually issued a preliminary injunction against Andrix, stopping it from using Alticor for its product based on Cost Pharmaceuticals' strong Advocor trademark. The court in this case also issued a preliminary injunction, this time stopping Camber from using purple for its pharmaceutical product, which is shown on the bottom, based on Nexium's purple trademark. In addition to keeping others from infringing your mark, you can also keep people from blurring or tarnishing your mark. In 1972, a New York court issued a preliminary injunction stopping a company from selling posters with "Enjoy Cocaine" because they risked diluting Coca-Cola's trademark. Now, there are instances where stronger words have become generic through trademark erosion. Aspirin, escalator, zipper, heroin, and yo-yo are examples. Here we have examples of trademarked words that have been in danger of eroding. Xerox, Band-Aid, Kleenex, Velcro, Legos. The companies that own these trademarks are taking steps and have taken steps to prevent their trademark words from becoming generic. Now, one important strategy that you might want to think about for obtaining trademark protection on a product's appearance is to first obtain a design patent. If you get a design patent, it's going to give you 15 years where your competitors can't use the design. During that time, you can work to have your design associated with you as the source so that even after the design patent expires, you can enjoy trademark protection. So on this slide, we have a couple of trademark strategies. You want to strategically develop marks, use some of those stronger words for maximum protection, conduct a clearance search to make sure no one else is using your mark, register your mark with the PTO to obtain benefits, protect against erosion, use the TM symbol, or if your mark is registered, the R with a circle around it, monitor use of your mark by others, and if needed, enforce it either with cease and desist letters or litigation. Now, as you develop your IP portfolio, you can keep these 4 strategies in mind. You want to carefully choose the type of IP you pursue, run your business with IP in mind. You should be thinking about your IP and IP implications when you enter into agreements, make statements to agencies, and when you disclose information. Third, you want to monitor others' IP. You don't want to be in a position where you have developed a strong IP portfolio, only to realize, for example, that you're infringing somebody else's patent. Fourth, remember that timing is critical. So this includes the timing for deciding which type of IP to pursue, as well as the timing for pursuing it. So we have a little bit of time for questions here. I think we have some coming in, but we just wanted to remind everybody that our role here today is to offer general insights and not legal advice. And with that, we thank you for listening, and I'm going to turn it back to Julie for any questions we've got.
All right, great. Thank you guys very, very much. I appreciate the presentation. We do have some questions coming in, and feel free, if anyone's online, to continue to add those questions into your questions panel. If you have questions, please submit them, and we'll try to get to them. So thank you all for hanging on as we address these. So first question up, can you expand a bit on invention being operative and an invention being enabled, and are they the same?
Well, first of all, this is David. I think that the answer to that question is that they're not the same. Being operative, meaning having utility, is a separate requirement. It's a requirement that's distinct from being enabled, although they are related. It could be that one would have an operative invention, but you have not demonstrated how to make and use it. Doesn't mean it's not operative. Maybe it would be operative. But the court has made clear, and Atlas has made clear, that these are 2 different requirements.
All right, great. How much data are needed to show an invention works?
Well, first of all, you don't have to provide. In fact, the court was very careful to say that you don't have to have experimental data in order to demonstrate the operability or the enablement of an invention. In fact, in the U.S., sometimes experimental data is not available at the time that there's filing of a patent application, and additional data is provided after the fact, and that's perfectly allowable. But there still has to be a basis for demonstrating, based on what's known in the art or based upon some basic information, that there's utility there and that one could make and practice the invention. An example that comes to mind is when you're dealing with treating a patient, for example, with a particular drug. At the time that you file the patent application, it's very unlikely that you're going to have a compound that you've dosed into humans. But you may have some mice or rat data, for example, that demonstrates that it has a particular effect in the animal, and the courts have said that kind of data is sufficient if there's a known connection between for example, the treating that in a animal model and the ability to go into humans later.
All right, thank you. Another question. Here we go. Building upon the example that you provided that had the downloading screenshot example, I think it was Corn Ferry, I believe was the example you were providing. So yeah. In a related example, if someone brings an expert to the team, such as a lot of startups obviously have consultants or new hires, or any company may for that example, how is it possible, if at all, to minimize the risk of those individuals claiming IP from former employment? Is there anything, that could then be applied unknowingly to the new company? Is there anything that could be done to minimize risk of that transference of IP?
Yeah, so in these cases, we're seeing employees being sued or charged criminally, but then people are also suing the new companies. And so the question is, who's actually misappropriating the trade secrets? And generally, it's the employee that's doing so. So as you're onboarding employees, you want to have confidentiality agreements, and then you can also consider putting provisions in your employment agreements that relate to trade secrets and the fact that the employee is not bringing with them information that they're not supposed to be bringing.
All right, thank you. And then I think we have one final question here. A lot of practice to transition innovations coming out of academia and transitioning them into commercial products. Sometimes universities hold the IP and give a license to commercialize to the given new startup. Are there other paths forward that seem to work well from your perspective?
I think licensing is probably the thing that I see most often between universities. You can assign different rights, or universities might even transfer the IP itself, although I would imagine that the university would expect something in return. David, I don't know if you've seen something in your experience.
Well, sometimes that's limited based on what the university can do, because a university is often did the research under a federal grant, and so sometimes there's restrictions. But licensing is a very common. Sometimes it's an assignment, but I think that's the most common way for them to monetize the IP.
All right, great. Thank you. Well, thank you guys very, very much for your time today and sharing that experience with us. In closing, just want to remind everyone that we do have the annual GC3 Innovators Roundtable coming up in May. May 7th is the GC3 Technology Showcase, followed by the Innovators Roundtable May 7th through 9th, all at Procter & Gamble and in Cincinnati. And the registration is now open online, so please go ahead and do so. So again, help me thank both David and Shana. And if you have any questions, please don't hesitate to contact us. Thank you.